Good morning, everyone. First of all, I would like to thank the Romanian notaires that invited me to come today to be part of this panel. My goal today is, after a short presentation, which is going to set the topic, is to give you a reminder of the rules that apply in the international context of private international law in the field of succession. I will then browse the main contribution brought by the EU regulation in an attempt to simplify cross-border succession resolves. And finally, we go through a couple of practical cases to make it more lively. These days, many expatriates, also known as expats, live a happy life in or outside a EU member state, far from their home countries. The stay abroad open in all regularities some opportunities for the brave one that are accepted to go working abroad, new opportunities. The other side of the coin is that their stay abroad makes the legal environment much more complex. In some multinationals, you're offered a feel-free, safe package when you go abroad, with the promise that we will retrieve you and your family in case something happens. But all these expats are well advised to take some precautions anyway. As long as the expats are happy and healthy, there is no main problems that arises. It's when the expats passes away that the question will appear of what will become of the assets that are situated in the home countries, or the assets that are located in the country where they are working for. The experienced lawyer's answer to that question would be, it depends. It's always quite complicated to know which law is going to apply. Apart from other factors, the relevant legal cornerstones are the deceased citizenship, his last domicile, his date and place of death, especially if he has died in a member state of the European Union, and if so, whether he passed away in Great Britain, in Ireland, or in Denmark. Until recently, the existence of different national rules made inheritance involving more than one country complex and costly. Depending on the countries, the criteria that determines which law is going to apply to the inheritance are called connecting factors, and they can vary from one country to another. There are two major systems in the world, and they are in opposition. There is the unity system and the cessionist system. In the unity system, the law applicable to the inheritance spreads to all the estate of the deceased person. It rules both immovable and movable assets wherever they are located. The connecting factor in some countries is the nationality of the deceased person. This is the case, for example, in Albania, in Algeria, in Saudi Arabia, in Austria, in Green Cape, in Congo, in Croatia, in Estonia, in Ghana, in Greece, in Hungary, in Iraq, in Kuwait, or in Mali, in Morocco, in Nigeria, in the Philippines, in Rwanda, in Senegal, in Sudan, in Sweden, in Czech Republic, in Syria. I think I just gave an appendix to the organizer, so if you're going to get the whole list of the countries, so you don't have to write down everything. In some other group of countries, this is the domicile, which is the connecting factor, and this is the case for Argentina, Brazil, Ecuador, Iceland, Israel, Romania, Russia, with some exceptions. In some other cases, the connecting factor is the lex rei cite, which is the location of the assets, movable or immovable, and this is the case in Mexico, in Panama, and in the Uruguay. So this is it for the unity systems. In some other country, we've got what we call the secessionist system or dualist system. I think that dualist is not the appropriate word because you'll see that for some countries, the connecting factors are more than 2 connecting factors. So that's why I think secessionist is better. So there is one connecting factor for the movable assets and one connecting factor for the immovable assets. First group of countries is when the connecting factor is the lex rei cite for the properties, real estates, and the last domicile for the movable assets. In this group of countries, we've got South Africa, we've got Australia, we've got Bahamas, we've got China, we've got France, we've got United Kingdom, we've got Luxembourg, we've got Madagascar, Malta, Mauritius, the New Zealand, Pakistan, Singapore, Thailand, Tanzania, and some more. Another group uses nationality of the deceased person as the connecting factor for the movable assets and the location for the real estates. This is the case for Benin and Monaco. And in some other cases, it's an option. It's the case in Burkina Faso. It's either the national law or the domiciles that turns out to be the connecting factor. And in some other country like Tunisia, there are many different connecting factors that applies according to the assets that are involved in the inheritance. The partition of the international succession was leading to a plurality of applicable law, which does not lead to ensure resolved inheritance, to secure inheritance resolves. The new EU legislation makes cross-border inheritance simpler by clarifying which EU country's court will have jurisdiction to deal with the inheritance and which law the courts will apply. On the 4th of July 2012, the European Parliament and the Council approved Regulation number 650/2012, which covers the jurisdiction, applicable law, recognition and enforcement of decisions, and acceptance and enforcement of authentic instruments in matters of succession. It also creates an European Certificate of Succession. The regulation is also known as Brussels IV. The regulation applies to the succession of persons who died on or after the 17th of August 2015. However, the regulation safeguards the validity of disposition of property upon death or the choice of law made by the deceased in a will, in a joint will, or an agreement as to succession, if made before the above date. In terms of temporal application and transitional provisions, it is important to note that this regulation also safeguards the validity of acts of succession made prior to the 17th of August 2015, as long as they respect the conditions set out in the regulation. The European legislation in question applies to all member states with the exception of United Kingdom, Denmark and Ireland because of their special position in relation to the area of freedom, security, justice and to the Treaty on Functioning of the European Commission. The EU regulation is based on three fundamental principles. The first principle is jurisdiction and application to all of the assets of the deceased regardless of their situation and location. The second principle is that it establishes the general rule, the connecting factor as I explained, of the habitual residence of the deceased at the date of the death, but it does not establish any minimum residence period to meet the requirement of the rules. This means that habitual residence has to be assessed in the light of the factual circumstances of the deceased, in particular, the duration and regularity of the deceased residence in the state in question, as well as the conditions and reasons for its residence. The third principle is that the law applies to the deceased succession under the new regulation, applies to the entire estate that falls in the succession. The regulation applies to all aspects of the succession, from the date the process begins until the final distribution of the estate. However, the regulation excludes everything related to gifts, like insurance contract, trusts, matrimonial property regimes, family maintenance obligation, the nature of property rights and taxation. The 5 cornerstones of the EU regulations are the following. First of all, it's a general rule and there is a universal application of the EU regulation. The EU regulation establishes the law of the habitual residence of the deceased as the only connecting factor. The aim of this is to designate a court with jurisdiction to decide on the entire estate of the succession and to designate the law applicable to the succession. It means that in order to decide the habitual residence, the authority who is dealing with the succession must carry out an overall evaluation of the circumstances of the life of the deceased person during the years prior to the death or at the time of the death. To achieve this, the authority must take the relevant facts into consideration, in particular, the duration and the regularity of the residence of the deceased in the state in question, as well as the conditions and reasons for this residence. In the light of the above, when it comes to international jurisdictions, the following provision of the regulation have to be considered. This is article number 4. I quote, "The court of a member state in which the deceased had his habitual residence at the time of death shall have jurisdiction to rule on the succession as a whole." The Article 5 displays the choice of court agreement. The Article 6 for declining of jurisdiction in event of the choice of law. Article 22, the choice of law by itself. The first paragraph of the Article 21 addresses the applicable law and provides that, unless otherwise provided for in this regulation, the law applicable to the succession as a whole shall be the law of the state in which the deceased had his habitual residence at the time of death. Article 20 of the regulations provides that any law specified by the regulation shall be applied whether or not it is the law of a member state. In certain cases, determining the habitual residence of the deceased person may be complicated. This is the case when the deceased, for professional or economic reasons, have been living abroad in order to work, sometimes for long periods, but has maintained a close and stable relationship with his or her state of origin. As an example, a significant number of Romanian people emigrated to other member states or countries outside the European Union. In these cases, it is necessary to consider the term on which they are working abroad, how often they return to Romania, whether they have assets in Romania or in the country where they work, and even if they work abroad, if they invest and acquire assets in Romania. Another complex set of circumstances can arise when the deceased has lived alternatively in various states or has traveled between states without settling permanently in any of them. The second highlight of the regulation is the choice of law. As mentioned above, the regulation rules defined by the regulation, the general rules defined by the regulation is that the habitual residence of the deceased at the date of the death, except if the deceased has chosen the law of his or her nationality to govern the whole of his estate. Article 22 of the regulation mentions that a person may choose as the law to govern his succession as a whole, the law of the state whose nationality he possesses at the time of making a choice or at the time of the death. A person possessing multiple nationality may choose the law of any of the states whose nationality he possesses at the time of making the choice or at the time of the death. The testamentary provision may be in the following term. This is just an example. I, the undersigned, you put the name, the surname, the date of birth and such. And then you carry on with under regulation number 650/2012 of the European Parliament and the Council of the 4th of July 2012, the law of my nationality as the law applicable to my succession. I also choose the jurisdiction of the Romanian courts for the same purpose. In any such choice must be made expressly in a declaration that takes the form of the disposition of property upon death, for example a will, or result for the terms of this disposition. Furthermore, the Article 83 in its 4th paragraph provides that if the disposition of property upon death was made prior to the 17th of August 2015 in accordance with the law which the deceased could have chosen in accordance with this regulation, the law is deemed to have been chosen as the law applicable to the succession. We jump on the third highlight of the regulation. It's about agreements as to succession. In case of any agreement as to succession, the Article 25, first paragraph of the regulation provides that the agreement will be governed as regards of its admissibility, its substantive validity, its binding effects between the parties, including the condition for its dissolution, by the law which under this regulation would have been applicable to the succession of that person if he had died on the day which the agreement was concluded. Article 25, paragraph 2 adds that an agreement as to succession regarding the succession of several persons shall be admissible only if it is admissible under all the laws which, under this regulation, would have governed the succession of all the persons involved if they have died on the day of which the agreement was concluded. Despite the two provisions of Article 25, the law allows the party to choose as the law that governs the agreement as to succession the law than the person or one of the person whose estate is in question could have chosen under the terms of the Article 22 of the regulation. The fourth main contribution is the public policy under the Article 35 of the regulation, and in exceptional circumstances and for public interest reasons, the authority responsible for the matter may refuse to apply certain provisions of foreign law whenever their application in a specific case is manifestly incompatible with the public policy of the member state in question. And last but not least, the EU regulation has created what we call the European Certificate of Succession. The EU regulation also allows the beneficiaries of a succession to deal with the whole process with a single authority, thus avoiding duplication of procedures and costs. For this purpose, the regulation created the European Certificate of Succession, which allows the heir or the administrators of the estate to prove their capacity to any authority in the member states without the need of further formalities. In this respect, Article 4 of the regulation determines that the courts of the member state in which the deceased had his habitual residence at the time of death will have jurisdiction to rule on the succession as a whole. In the highlight of all the above, today we are seeing a clear call for succession planning that takes into consideration the mass of domestic and international legislation and the free movement of people. As we see it, it's time for us to put aside any fear of considering death and organize our succession in good time in an informed way, principally to avoid legally complex situations and legacies that create conflicts between your heir. In a way, the new regulation on succession is a useful contribution and a warning about the situation we live in today. I mean, free movement of people and properties in the European Union. Because of this, we hope that people take on board the situation that exists and approach the issues of succession in a very natural way. So now to illustrate what I've just been summarizing, we're going to go through a few cases. So my first case is about the universal application of the regulation. And this is Mr. Jones. He's Australian and is living in New York, where he passes away after the 17th of August 2015. In his estate, we can find some bank accounts in Romania. So which law is applicable to his succession? Article 21 of the regulations gives competency to the law of the habitual residence of the deceased at the time of his death. So the law of the state of New York is then applicable. It does not matter if it is a third-part state. And for that, the Article 20 specifies that any law specified by this regulation shall be applied whether or not this is the law of a member state. A second case on the universal application of the regulation is a bit of the same. You know, it's Mr. Itaka, a Japanese, has his domicile in Romania, and he dies there after the 17th of August 2015. In a will drawn up in Romania, he has appointed his national law to rule his succession. Is the choice of law of a third-part state valid? The succession of Mr. Itaka will be governed by the Japanese law, although this is not the law of a member state, whether or not Japan accepts what we call the professio juris, which is the choice of law. In this case, there won't be any conflicts of applicable law because Japan connecting factor is the law of the nationality. We carry on with the professor juris made prior to the EU regulation. Mr. Kiefer is from Luxembourg. He lives in Bucharest in Romania. He's consulting his Romanian notary on the 12th of July 2014. He has heard that it is possible to choose the law applicable to his succession, and he wants to choose straight away the Luxembourg law. Was the professor juris of Mr. Kiefer valid? The answer is yes, it is valid. Indeed, the Article 83 of the regulation in its first paragraph is mentioning that the new dispositions shall apply to the succession of person who died on or after the 17th of August 2015. But it also appears to apply to the choice of law that have been made prior to this date. The Article 83 in its second paragraph states that where the deceased has chosen the law applicable to his succession prior to the 17th of August 2015, the choice shall be valid if it meets the condition laid down in the chapter 3rd, or if it's valid in application of the rules of the private international law which were in force at the time of the choice was made in the state in which the deceased had his habitual residence or in any states whose nationality he possessed. The Article 83 submits the validity of the choice to certain conditions. It's either it respects Chapter 3 or it respects the international private law that were already in application at the moment of the choice in the state in which the decedent has his habitual residence or the nationality. Consequently, in our case, Luxembourg law was not admitting the choice of law for inheritance purposes, while, if I'm correct, according to the Article 2634 of the Romanian Civil Code, Romanian law was accepting it. So the professor juris of Mr. Kiefer is then valid. We've got now Mr. Schulz, which is a friend of Mr. Kiefer. He's also from Luxembourg, and he lived this time in Paris, in France, and is consulting his French notaire on the 13th of July 2014, because Mr. Kiefer told him that it's possible to choose the law of applicable to your succession, and he wants the Luxembourg law also to apply to his assets. Was the professor juris of Mr. Schulz valid also? The analysis is a bit the same as the previous case, but then it forks at some point. Neither Luxembourg nor France do permit the choice of law for inheritance purposes in their internal law. Consequently, the choice of Mr. Schulz needs to respect the condition of the Chapter 3, because for Mr. Kiefer, he was only respecting the law of the international private law, while in this case it's not possible, so we go to the Chapter 3 of the regulations. The choice is only open in favor of the law of the nationality of the deceased, and the choice must be expressly formulated in a disposition upon death. In this regard, the regulation mentioned in the Article 3 that must be considered as a disposition upon death, a will, a joint will, or an agreement as to succession. Mr. Schulz could then appoint the law of Luxembourg in a will. Regarding the condition of validity of the said will, Article 83 in its third paragraph states that a disposition of property upon death made prior to the 17th of August 2015 shall be admissible and valid if substantive terms and as regard from if it meets the condition laid down under Chapter 3, or if it's admissible and valid in substantive terms as regards forms in application of the rules of private international which were in force at the time of the disposition was made in the state in which the deceased had his habitual residence or in any of the states whose nationality he possessed or in the member states of the authority dealing with the succession. In this regards, particularly focusing on the formal condition of validity of the wills, we can note that among Chapter 3, we've got the Article 27. And this Article 27 is just a literal copy of the disposition of the Hague Convention of the 5th of October 1961 on conflicts of law relating to the forms of testamentary dispositions. Nevertheless, Article 75 of the regulation specifies that to all the participant countries of the Hague Convention, they will keep on applying the Convention of the Hague instead of the Article 27 of the EU regulation. Following the combinations of these Articles 83, 27 and 75 of the EU regulation, the form of the will of Mr. Schulz will be considered as valid in France and in Luxembourg if it fulfills the condition of one of the law identified by the Convention of the Hague of the 5th of October 1961, if those two states are participant countries. The Hague Convention, among a numerous applicable law that grants validity to a testamentary disposition, appoints the law of the state in which the disposition was made. Consequently, Mr. Schulz can choose straight away his national law to apply to his succession in a French will, and obviously this choice will be effective only if Mr. Schulz dies after the entry in application of the EU regulations. Now we've got Mr. and Mrs. Van Herp. They are Dutch citizens. They are living in Rotterdam. They are inquiring to their French notary about the property that they own on the French Riviera. They have heard from Mr. Kiefer again, a friend from Luxembourg, that it's now possible in France to appoint the law applicable to your succession. So the question is that they want to know if the choice they made in 2004 in the Netherlands in favor to the Dutch law will be recognized in France, or if they need to do it again. We need to have a look on Article 83 of the regulation, and we can see that in its second paragraph, the provisions are that where the deceased has chosen the applicable law to his succession prior to 17th August 2015, that choice shall be valid if it meets the condition of Chapter 3, or if it's valid in the application of the rules of private international law which were in force at the time of the choice was made in the state in which the deceased had his habitual residence or in any state whose nationality he possessed. The Netherlands, country of the nationality of Mr. and Mrs. Van Herp, have opted in to the Hague Convention of the 1st of August 1989 relating to the applicable law to succession upon death. This convention that applies to the Netherlands since the 1st of October 1996 allows every person to choose as the applicable law to his succession either the law of the state whose nationality he possessed, or the law of the state where he has his habitual residence at the time of the choice or at the time of the death. In this respect, Mr. and Mrs. Van Herp have made their choice 13 years ago. The choice of law made in the Netherlands is then valid accordingly to Article 83, paragraph 2 of the EU regulation. This is then not necessary to reiterate this choice with a specific reference to the EU regulation. Obviously, the choice of law will be effective in France only if Mr. and Mrs. Van Herp pass away on or after the 17th of August 2015. In case of death before this date, the French notary will apply the French law to the French property as the connecting factor before the entry of application of the EU regulation was the lex res cite. And it will not take in account the choice of law made by the spouse. It is also important to remind the parties that it would be wise for the will to contain the choice of law to be registered in France on what we call the will database. This is called the Fichier des dernières dispositions. This registration comes from the Convention of Bâle that was signed on the 16th of May 1972, which is actually in application in France and in the Netherlands for my case. The other participants countries, if you want to take notes, are Cyprus, Spain, Luxembourg, Turkey, Belgium, Portugal, Estonia, Lithuania and Italy. The Dutch notary can also ask his international connecting organism of the Netherlands to process the registration in France. And concerning the states that are authorizing the choice of law in their internal system, prior to the entering application of the EU regulation, I can give you the list if you want. There was Italy, Liechtenstein, Switzerland, Armenia, Belarus, Belgium, Bulgaria, Poland, Quebec, Kazakhstan, Ukraine, Romania, and Burkina Faso. And of course, each time it's very important to check the condition of the validity of the choice in each concerned state. The next case is about the competency of the jurisdiction. Mr. Popescu, a Romanian citizen, dies having his habitual residence in Germany. Most of his estate is located in Romania. His children ask the Romanian notary to deal with the inheritance. The Romanian notary, does he have competence to deal with the inheritance while the deceased was living in Germany? The answer to this question is positive. The EU regulation sets some rules of competency which assign the jurisdiction with a big J to address inheritance matters. In general, it appoints the jurisdiction of the member state in which the deceased had his habitual residence at the time of his death, it's Article 4, or in the condition related to Article 5 to 7 of the regulation, to the jurisdiction of the member states whose law was chosen by the deceased according to the Article 22. Nevertheless, according to the whereas number 20, in fine, the term jurisdiction should not cover non-judicial authorities of the member states empowered under national law to deal with the matters of succession, such as notaries in most of the member states where it is usually the case they are not exercising judicial functions. Consequently, the Romanian notaries who are not exercising judicial functions when they deal with inheritance cases should not be bound by the rules of competency of the regulations. In this regard, despite the applicable law is the German law, a Romanian notary can deal with the inheritance case without any connection with the location of the habitual residence of the deceased person. But in that context, my advice would be that the Romanian notary needs to get in touch with a German notary to get some advices about German law to address the inheritance case. Another case about the habitual residence. So Mr. and Mrs. Paladescu, Romanian citizen, have been living all their life in Romania. They were married with a prenuptial contract of separation. They decide to retire in France. Mr. Paladescu, a veterinarian, is now slowing down his activity in Romania. He's coming back in Romania every now and then, only for complex surgery cases. Mrs. Paladescu is a retired teacher, and she gets her pension from the Romanian government in Romania. Their 3 children are all adults, and they're all living in Romania. Mr. and Mrs. Paladescu have rented their house in Bucharest, and they have moved to France last winter to live in their former holiday house. And Mr. Paladescu dies of a heart attack 6 months after. He leaves behind him his wife and the 3 children, and some properties and bank accounts in both countries. What is the habitual residence of Mr. Paladescu? So we need to think this way. The EU regulation has chosen as the general connecting factor the habitual residence of the deceased person at the moment of his death. This is Article 21, paragraph 1. This law applies to all the estate of the deceased without any distinction between movable and immovable assets. The EU regulation have universal application. It means that it applies whatever is the law determined by its rules, whatever the citizenship of the deceased person or of these heirs, and wherever is the estate located. In the case of Mr. and Mrs. Paladescu, the question that arises is to know whether the Romanian law is still applicable or if it has switched to French law. In the EU regulation, there is no precise definition of what is the habitual residence. To clarify this point, we need to go to whereas number 23 to 25 of the preamble of the European regulation, because it gives some practical information and displays different situations. It is important to keep in mind that the whereas of the preamble are just a mean to help to understand or illustrate the articles of the regulation, and the notary's mission is to evaluate the circumstances of the life of the deceased within the last years of his life or at the time of his death. So the whereas mentioned that in order to determine the habitual residence, the authority dealing with the succession should make an overall assessment of the circumstances of the life of the deceased during the years preceding his death and at the time of his death, taking account of all relevant factual elements, in particular the duration and the regularity of the deceased's presence in the states concerned and the condition and reasons why for that presence. The habitual residence thus determined should review the close and stable connection with the state concerned, taking into account the specific aims of this regulation. The criteria of the habitual residence is different from the notion of domicile, which is currently used in other legal areas and especially in European law. For example, the notion of domicile is used by the The Hague Convention of the 14th of March 1978 for the marital regimes. Habitual residence is a more flexible criteria. it does not require to look for the willingness to establish durably in a state. In our case, the regulation required to investigate within the years before the death, which leads to Romanian law, also to investigate the situation at the moment of the death, which leads to French law. It also requires to inspect the duration and the regularity of the disease present in the state concerned, and this case that would lead to the French law, as Mr. Paladescu visits to Romania are only sporadic, and there is nothing surprising by quitting progressively his active life. The review of the condition and the reason of the presence of on the French territory reveals that the life of Mr. and Mrs. Paladescu, the center of their social and family life, was by now France. Family life, we need to understand by those two words that it is the life of the couple, stricto sensus, which does not include the residence of the 3 children who are, by the way, adults and independent. It is true that the couple has not sold the property in Romania, which is another hint, but and we can think that it could lead them to return to Romania. But as I said previously, with the connecting factor of the habitual residence, there is no need to take in account the future willingness of the deceased at the moment of the death. Mrs. Paladescu gets a pension in Romania, but this is just a small income. We can argue that. Or maybe the formalities of the transfer to France have not been completed yet. But whatever, this income, as I say, that they've got a prenuptial contract, is an asset of the surviving spouse, and it's not an asset that is falling in the estate of the deceased person. So in regards to all of this, it's on us to determine the habitual residence, and in my case, I think that it seems to be the French law that will be applicable to the inheritance of Mr. Paladescu. Another case about the professor juris. Mr. Durand, a French citizen, has his habitual residence in Bucharest. He owns a property in France, and he wants it to be ruled under French law in case of death. He's consulting a notary for that. Can he choose French law only for the French property? The answer is no. Article 22, paragraph 1 of the regulation allows every person to choose the law of the state in which he's got his nationality at the moment of the choice or at the moment of the death. But it states the law to govern the succession as a whole. The Article 23 is even more explicit in its paragraph 1. It gives the definition of the scope of the applicable law. It clearly sets that the law determined pursuant to Article 21 and 22 shall govern the succession as a whole. It means two things. First of all, that the law governs the all civil aspects of the succession, but also, as explained in the whereas number 37 of the regulation, it governs all the property forming part of the estate, irrespective of the nature of the assets and regardless of whether the assets are located in another member state or in a third-part state. These dispositions target one of the principal goals of the regulation, which is to ensure the unity of the succession resolving. In our case, the choice of Mr. Durand to have the French law governing only his French property will not find application. he has an alternative. Either he chooses the French law to govern his succession as a whole, or either he doesn't make any choice and then the Romanian law will govern all his inheritance assets as a whole, provided that his habitual residence is in Bucharest. Now we're going to go on the topic of the renvoi, which is quite complicated. We've got Mr. Bernard, a French national, who dies ab intestate in the UK, where he was domiciled on the 1st of January 2016. He was the owner of a property in France. So does the renvoi interfere to determine the applicable law to the inheritance of the deceased person? Mr. Bernard has passed away on the 1st of January 2016. The EU regulation is then applicable. Article 21 of the regulation mentions that unless otherwise provided for in this regulation, the law applicable to the succession as a whole shall be the law of the state in which the deceased has his habitual residence at the time of the death. In our case, Mr. Bernard was living in the UK at the time of his death. It should be the British law applicable to his succession. However, shall we consider a renvoi from the British law towards the French law? The Article 34 of the regulation admits the renvoi when two cumulative conditions. The applicable law is the law of the habitual residence of the deceased. It doesn't work when it's the applicable law because of a professor juris or because of the safeguard clause. We'll see later. And when the applicable law is the law of the third part state, which returns the competence either to the law of a member state or to the law of a third part state who applies his own law. UK, Ireland and Denmark are considered as being third part states to the EU regulation. In our case, the renvoi will interact. British international private law retains for real estate the connecting factor of their location. It's a lex rei cite. The French property of Mr. Bernard is located in France, so British law returns the competency to French law. For the remaining of the belongings of Mr. Bernard, I mean the property located in the UK or all his movable assets, the British law will be competent as its connecting factor for movable assets is the last domicile of the deceased person. In this case, we can highlight that the application of the renvoi ends up to tear apart the inheritance applicable law, which is in contradiction with one of the principles of the regulation, which tends to end up to have one unique law applicable. If you want, you can note a list of countries that are excluding the renvoi, some others that are agreeing to the renvoi of the first degree renvoi, and some others that are accepting the second degree renvoi. Exclusion is Algeria, Brazil, Canada, Quebec especially, China, Denmark, Egypt, Emirates, Greece, Iraq, Jordania, Kuwait, Lebanon, Libya, Morocco, Norway, the Netherlands, Peru, Dominican Republic, Somalia, Sudan, Sweden, Syria and Tunisia. Accepting the first degree renvoi is Albania, Argentina, Belgium with some special rules, Congo, Cuba, Spain, Estonia, Russia, Hungary, Japan, Liechtenstein, Lithuania, Luxembourg, looks like the Olympic Games, you know. Mexico, Monaco, Poland, Portugal, Romania, Senegal, Switzerland, Thailand, Togo and Vietnam. And the second degree renvoi is accepted by Germany, Austria, Burkina Faso, Finland, France, Italy, United Kingdom, Turkey and Venezuela. I mentioned the safeguard clause, so now we're going to do a case about this. Mrs. Posa is a French national. She's quite old, she's 91 years old, and 2 years ago she was raised by Alzheimer's disease. Her children has moved her from France to a specialized retirement house in Tournai in Belgium. This decision was made by agreement between the doctors and the children, because she cannot express her consent anymore. She died in Belgium on the 25th of February 2017. Where is the habitual residence of Mrs. Posa? Article 21 of the regulation gives competency to the state where the deceased has his habitual residence. Can we consider that Mrs. Posa had her habitual residence in Belgium? It looks like she had the center of her interest in Tournai, Belgium, and that this residence was established there since a certain time. Nevertheless, it is obvious that Mrs. Posa has never expressed the choice to establish herself in Tournai and to integrate any Belgian social circle. The Article 21 in its paragraph 2 is mentioning an exception. When the deceased was manifestly more closely connected with a state other than the state whose law would be applicable under paragraph 1. So is the rule applicable is this rule applicable to Mrs. Posa's case? It does not seem so. The whereas number 25 consider the application of the second paragraph for deceased person recently established on a new territory, while all circumstances of the case lead to believe that he was manifestly more closely connected with another state. Mrs. Posa does not really fulfill those criteria. A more relevant application of the safeguard clause is mentioned by the paragraph 2 of the Article 21. Is approached in the whereas number 24, and that whereas can help us. This position concerned a deceased person who was working abroad while he was keeping a closer and stable connection with the state of origin. Transposed to Mrs. Posa's case, one could argue that Mrs. Posa still had a family and social circle in France. This is why I think that we can also say that Mrs. Posa's succession can be governed by the French law. It would be different if the move to Belgium was initiated by the wish of Mrs. Posa, especially if the wish to move to another country is motivated by economics or opportunity reasons. We need to be careful because nowadays there are some retirement houses that are becoming international, and they're offering a choice to be moved in some departments abroad, such as Portugal or Asia. The exception clause of paragraph 2, article 2 is not applicable in those cases because it clearly refers to some economic and opportunities reason to move somewhere else. The French advice for that would be to consider that in most of the cases it's probably safer to appoint the law of the location of the retirement house, especially if the elderly person has made the choice to move there and if the connection with the state of origin has unraveled since the move. The application of the safeguard clause of Article 21, paragraph 2 has to remain absolutely strictly exceptional. Now a case on the European Certificate of Succession. A retired man Mr. Olson dies domiciled in France, with some movable assets in France, some properties in France, Poland and Sweden. He leaves a Swedish wife based in France and 2 children based in Sweden. The heirs want to sell the Polish property. How can they get and use a European certificate of succession? First of all, we need to inquire about the application for a European certificate of succession introduced by Swedish children in France. The ECS is interesting in this case because it will circulate between the 3 different countries. The EU regulation has created an application form to require the ECS. You should note that it's not compulsory for the heirs to use this application form. We can process straight away the ECS without getting an application for the form. But it's highly recommended to have the heirs requiring the ECS through the application form, because in a certain way it's sort of protecting you from the declaration made by the heirs. The applicable law in our case is the French law, as the habitual residence of Mr. Olson was in France. The heir will have to introduce their application of requirement to the French notaire. According to the Article 4 and 64 of the EU regulation, is the only competent authority to deliver this certificate. The information to be given are very classical. It's the details concerning the deceased person, the applicant, the surviving spouse, the existence or not of a will, existence or not of prenuptial contract and such. The French notaire will have to state the existence of a prenuptial contract, and if there is none, he will have to indicate the marital status of the deceased. There again, it's important to note that the determination of the legal marital status will have no effect towards Sweden and Poland, because the EU regulation about marital status has not entered an application yet. It means that the legal authority of each country involved will have to apply its own connecting factors to determine which is the applicable marital status according to its own international private law, and it leads different results to occur. The EU regulation mentioned that the heirs will have to provide any necessary document to the competent authority, such as birth certificates and such. The French notaire will, in our case, will require from the British birth certificates translated in French and with the apostille, as France and Sweden are both participant states to the Convention of The Hague of the 5th of October 1961. Article 74 states that the only ECS is exempt, is exempt of any apostille or legalization process, not the document that needs to be provided in order to get the ECS drawn up. The French notaire will then issue the ECS within no delay, as long as there is no contradiction or contestation within the document he's got in his possession. The ECS report the same information contained in the requirement application form, filled by the heirs, after everything has been checked. The originality of the ECS is retained by the issuing authority. It's the Article 70 of the regulation. And the issuing authority will only give copies, certified copies, to the applicant or any person demonstrating a legitimate interest. In our case, the surviving spouse and the 2 children can each ask for 1 copy. Each copy will be valid for 6 months. It can be prorogated or renewed. The Swedish heirs will transfer 1 of the copies to the Polish notaries in charge of the sale of the property in Poland. There is a presumption of veracity given by the EU regulation to every ECS. It produces its effects in every member state. The French notary will have to register the ECS on a registry book he will hold in his practice, and that's the same for every issuing authority. On the registry appears the name of the person who has given a copy of the ECS, the number of copies that have been issued, and the expiry date of each copy. There is a discussion right now about whether bringing a ECS to the land registry can be an valid application to operate a ownership transfer. In some countries, and most of the country, like France, yesterday I was in a conference in Paris, and I asked one of the top professional in charge of all those things, and they think that in Poland it's possible to bring the CSE straight to the land registry and to operate the transfer of ownership just with that. In France, you need to have a special deed drawn up for that, called an attestation of attestation de propriété. So maybe some one of you's got the information about Poland, but it looks like it's possible to do it down there. Public policy. It's going to be my last case. Mrs. Auburn is American. She lives in New York, and she's owning a property in France. She was married with Mr. Black. She had, from this marriage, 3 American children, Julia, Michelle, and Janet. Michelle was married to a Frenchman, and she had 2 sons, Julian and Paul. They are living in France with their father since Michelle is dead. Mrs. Auburn has drawn up an American will appointing the law of the state of New York to govern her entire estate. She has appointed her husband to be the only beneficiary of her estate. The question is to know if Julian and Paul can claim for a part of the inheritance of their grandmother. As a combination of Article 21, paragraph 1 about habitual residence, Article 22, paragraph 1, professor juris, Article 34, paragraph 2, the renvoi, declinatory of competence, the law of the state of New York will govern the succession as a whole. Testamentary succession are governed by the same law determined for ab intestate succession. In our case, this is the law of the state of New York that applies. The legacy made in the provision of Mrs. Auburn's will disinherit Paul and Julian. The only way they can activate their forced heirship right is the angle of the public policy. Article 35 of the EU regulation states that the application of the law of any state specified by the regulation may be refused if such application is manifestly incompatible with the public policy of the forum. Article 27, paragraph 2 of the proposal of the regulation that was made on the 14th of October 2009 was mentioning, in particular, the application of the rule of the law determined by this regulation may not be considered to be contrary to the public policy of the forum on the sole ground that its clause regarding the reserved portion of an estate differ from those in force in the forum. This provision, full of ambiguity, has not been integrated in the EU Regulation 650/2012. And since the EU regulation came in application, there are some discussion running about the compatibility of a foreign law which does not recognize the forced heirship concept in its compatibility with the international public policy. The EU Commission is just mentioning as being some criteria of the public order to the public policy to block the application of the law when there is a discrimination again based on religion or on I think sex also, gender, sorry, and things like this. And it is not precisely mentioned by the European Commission that forced heirship is one of the blocking areas in which the policy must interact. In our case, can the grandchildren claim in application of the exception of the international policy on the ground of the heirship of the forced heirship? Lately in France, that was last summer, we have seen one tribunal deciding that the claim could refer to the international public policy if the privation of the forced heirship leads the heirs to end up in a deprived situation. We need to take this decision very carefully because it's just an individual decision and it must be amended by the Court of Appeal or some other decision later on. Well, we've finished with the case, and I'm just going to add something about the professor juris that we discussed yesterday in Paris. It's about the professor juris. I said that the professor juris is valid when it's been done in a country where that was accepting it in his internal law, or in one of the member states that have signed the EU regulation. We've got in France, maybe you've got the same problem in Romania, problems with Great Britain about this, because sometimes professor juris are we do the professor juris for British people in France, and they're recognized as valid because France has signed the EU regulation. But some solicitors in the UK are giving the advice to British citizens to make a professor juris on the UK territory, while the UK internal system does not recognize the possibility to appoint the law of your nationality to govern your succession as a whole. And so this is normally how it runs, but lately I had a solicitor on the phone and she was telling me that because of the will being drawn up in the UK in English, there was an implicit professor juris made in the will. It appears from the discussion we had yesterday that it's clear, it's crystal clear that a country who does not accept express professor juris cannot argue to accept implicit professor juris. That would be a nonsense. Thank you very much for your attention.